Hello! Welcome sa Kwentong Attorney. So, before anything else, here are my disclaimers. So, first, nothing beats reading cases in the original. Second, I am not guaranteeing that by listening to this vlog, you will pass your law school, your law subject, or you will even get a passing grade in your recit. Okay? And third, this is not a legal advice. So for this vlog, I will be discussing the effect and applications of laws. So in our civil code, in the Civil Code of the Philippines, these are articles 1 to 18, but I won't be discussing everything, meaning I will not discuss articles 1, 2, 3 up until 18. But I will discuss the pertinent articles from articles 1 to 18. So, yung mga medyo controversial or yung yung talagang i-discuss siya sa school and even sa bar. So, first, Article 2. Article 2 states that laws shall take effect after 15 days following the completion of their publication in the official gazette, unless it is provided otherwise. So, this code shall take effect 1 year after such publication. So, kung ang batas ay may nakalagay na kung kailan siya magte-take effect, then dun siya magte-take effect. Pero kung walang nakalagay kung kailan siya magte-take effect, yung phrase na to na law shall take effect after 15 days following the completion of their publication in the official gazette will apply. So, ang question, dun ba sa mga batas na may nakalagay na kung kailan sila magte-take effect, kailangan pa ba ng publication? So, dun masasagot yan ng mga cases na i-discuss natin later on. Now, this code shall take effect 1 year after such publication. So, ito daw civil code will take effect 1 year after such publication. So, take note kung kailan pinublish yung civil code, and then 1 year thereafter, yun yung effectivity ng civil code. Okay? So, let's go to the cases. Article 3 muna pala. Article 3 states that ignorance of the law excuses no one from compliance therewith. So, bakit ko usually pinagsasama ko yung Articles 2 and 3 kasi related naman sila. Why are they related? Kasi yung publication, kailangan siya to notify the people of what that law is, kung ano ba yung napapaloob doon sa batas na yon. Kung hindi siya published, paano malalaman yun ng mga tao? So, Article 3 would not apply. So, I usually discuss Articles 2 and 3 ng magkasama. So, let's go to these cases. The first case is Honasan versus the Panel of Investigating Prosecutors of the Department of Justice et al. In 2004. The second one is Tanada versus Tuvera in 1986. And the third one is Gatbonton versus NLRC and Mapua in 2006. So, the first case is Honasan. So, let's go. Ayan. So, I already highlighted yung cases. So, for the cases, back when I was in law school, I was using Lawfield. So, you just type lawfield.com. You can already see cases. Yung cases doon at saka yung mga batas. If wala sa law, primarily Lawfield yung ginagamit ko. If wala sa Lawfield, I also check chanrobles.com. So, they're both helpful to me when I was in law school. So, in Honasan versus the Panel of Investigating Prosecutors, so what happened here? So, in the early morning of 2003, si Captain Gambala, for in behalf of the military rebels occupying Oakwood, made a public statement aired on national television. Sinabi niya that they are withdrawing their support to the chain of command of the AFP and the governance of then-President Gloria Macapagal Arroyo. And they are willing to risk their lives in order to achieve the national recovery agenda of Senator Honasan. I'm not sure if law students still know who Senator Honasan is, pero he is a senator. He was a senator at least before. I'm not sure if he is still a senator today. Okay, so they believe that the only program that would solve the ills of society is theirs. Okay, so next. So the panel of investigating prosecutors of the DOJ sent a subpoena to petitioner, meaning kay Honasan, for preliminary investigation. Later on, you would know in your criminal law subject, probably Crim 1, no, Crim Pro pala, criminal procedure, you would know what preliminary investigation or PI is. So, the petitioner argues that even if deputized daw, si DOJ panel is without authority since yung OMB-DOJ Joint Circular Number 95-001 is inoperative due to lack of publication. So, ano ba yung OMB-DOJ Joint Circular Number 95-001? Ito is an internal arrangement between DOJ and the Office of the Ombudsman. Ay, sorry, mali. Yan. Ito. Yung OMB-DOJ Joint Circular Number 95001 is all about handling complaints filed against public officers and employees, the conduct of preliminary investigation, preparation of resolutions and informations, and prosecution of cases by provincial and city prosecutors and their assistants. So, ina-argue ni Honasan na parang even if deputized pa yung DOJ panel na yan, wala pa rin silang authority since yung OMB DOJ Joint Circular, hindi siya pinublish. Sabi naman ni ng DOJ panel, hindi naman na yan kailangang i-publish because it's just internal arrangement between DOJ and the Office of the Ombudsman. So, yun yung arguments nila. So, anong sabi ng korte? Ayan. Sabi ng court, petitioner's contention that the OMB-DOJ Joint Circular is ineffective on the ground that it was not published is not plausible. So, kasi daw, only circulars and regulations which prescribe a penalty for violation should be published before becoming effective. This on the general principle and theory that before the public is bound by its contents, especially its penal provision, a law, regulation, or circular must first be published and the people officially and specifically informed of said contents and its penalties. So, yung OMB-DOJ Joint Circular, hindi naman siya nagko-contain ng kahit anong penal provision or it does not prescribe a mandatory act or prohibit any under pain or penalty. So, hindi siya kailangang i-publish because it's just an internal arrangement. Okay? Now, let's go to Tanada versus Tuvera naman. Okay? Yan. In Tanada versus Tuvera, petitioners seek a writ of mandamus to compel respondent, public officials, to publish and or cause the publication in the official gazette of various presidential decrees, letters of instructions, general orders, proclamations, executive orders, letter of implementation, and administrative orders. Okay. Anong sabi ng korte? The court ruled that publication in the official gazette is necessary. So, meaning, kailangan siya only on those cases when the legislation itself does not provide for its effectivity date. For then, the date of publication is material for determining its date of effectivity, which is yung 15th day following its publication. Article 2 does not preclude the requirement of publication in official gazette even if the law itself for the date of its effectivity. Kanina I mentioned yung rules. So first one, if yung batas nilay down na niya kung kailan yung effectivity, then that's it. That's the effectivity of that law. Second, kung wala yung batas na date of activity, mag-a-apply yung phrase na 15 days after the publication. Pero, hindi naman sinabi na kapag ka may nakalagay ng effectivity yung batas, hindi naman sinabi na fino-forgo na yung publication. Meron pa ring publication. Pero ito yung rule. Makikita mo dito sa case na ito. Without such notice and publication, there would be no basis for the application of the maxim ignorantia legis non excusat. It would be the height of injustice to punish or otherwise burden a citizen for the transgression of a law of which he had no notice whatsoever, not even a constructive one. So, kaya sabi ko kanina, I usually discuss Articles 2 and 3 because yung Article 3, yung ignorance of the law, excuses no one from compliance therewith, hindi siya mag-apply kung wala namang publication. Okay? So, here, going back to the case, the publication of all presidential issuances of a public nature or of general applicability is mandated by law. Obviously, presidential decrees that provide for fines, forfeitures, or penalties for their violation or otherwise impose a burden on the people, such as tax and revenue measures, fall within this category. Other presidential issuances which apply only to particular persons or class of persons such as administrative and executive orders need not be published on the assumption that they have been circularized to all concerned. So, it is needless to add that the publication of presidential issuances of a public nature or of general applicability is a requirement of due process. It is a rule of law that before a person may be bound by law, he must first be officially and specifically informed of its contents. So, yon. Okay? And the last case for this is si Gatbonton. To. So, ito, si Gatbonton, he is an associate professor of Mapua Institute of Technology or the MIT. So, nung 1998, may student na nag-file sa kanya ng complaint for unfair or unjust grading system, sexual harassment, and conduct unbecoming of an academician. So, because of that, he was placed under a 30-day prevention period from January 11, 1999. So, take note, I highlighted this in green because it has significance later on. Take note of the January 11, 1999, that's the start of when Gatbonton was placed under preventive suspension. Okay, so he was placed under a 30-day preventive suspension because his continued stay during the investigation may affect his performance as a faculty member as well as the student's learning, and that the suspension will allow petitioner to prepare himself for the investigation and will prevent his influences to other members of the community. Okay. Now, sabi ni Gatbonton, yung CA decision daw mali. Ina-argue niya kasi na yung preventive suspension, wala siyang justification under the Mapua Rules and Regulation because yung preventive suspension niya noong January 11, 1999, hindi pa siya na-promulgate because it was published only in February 23, 1999. Okay. So, anong sabi ng korte? Meron kasing act or may batas kasi na nag-i-impose sa mga educational or training institutions to promulgate rules and regulations in consultation with and jointly approved by the employees or students or trainees through their designated representatives, prescribing the procedures for the investigation of sexual harassment cases and the administrative sanctions therefore. Ito yata yung Anti-Sexual Harassment Act. Okay. Pero kasi, note that si MIT, pinublish niya lang yung rules and regulations niya pursuant to RA number 7877 on February 23, 1999. And in Tanada versus Tuvera, it states that all statutes, including those of local application and private laws, shall be published as a condition for their effectivity, which shall begin 15 days after publication unless a different effectivity is fixed by the legislature. So, based on that, Mapua Rules is one of those issuances that should be published for its effectivity since its purpose is to enforce and implement the Anti-Sexual Harassment Act or the RA number 7877, which is a law of general application. In fact, Mapua Rules itself explicitly required publication of the rules for its effectivity. So at the time of the imposition of petitioner's preventive suspension on January 11, 1999, yung Mapua Rules were not yet legally effective. And so, yung suspension, walang big legal basis. Yun. So, talo sila.